This is the Hidden Killers Podcast with Tony Bruschi and continuing coverage of the case against Bryan Kohberger.
Bryan Kohberger is, of course, facing the death penalty for the murder of the 4 college students in Idaho. It's not an exaggeration or a headline. It's the reality. And in cases like this, every move is a calculation. Every look, every word, especially one particular decision that can change the entire trajectory of a trial, whether or not the defendant takes the stand. Here's the thing. In American courtrooms, the idea of a defendant testifying in their own defense sounds noble, right? Like something out of a movie where the accused finally speaks their truth, looks the jury in the eye, and turns the whole case around. But in real life, it rarely works that way. In fact, it usually backfires hard. Statistically, defendants who testify are convicted at higher rates than those who don't. There's a reason most defense attorneys practically beg their clients to keep their mouths shut. It's not because they don't believe in them. It's because the courtroom is a minefield. When you testify, you're not just telling your story. You're opening yourself up to a surgical, relentless, often brutal cross-examination from the prosecution. You're inviting someone whose full-time job is to dismantle your credibility, to come at you with everything they've got. And that's before we even get into how jurors might misread your tone, your body language, or your choice of words, or clothing if you have the option. We're going to dive into all of this, and I'd love to get your feedback in the comments on YouTube if you're watching us there, or on X, wherever it may be. I want to hear your thoughts on this case, and be sure to press subscribe if you're on YouTube right now so you don't miss any of our coverage of this case. We have tons and tons, hundreds and hundreds of videos on it, and we're going to continue to cover this all the way through trial, appeals, wherever it may go. So if you don't want to miss any of that, hit subscribe on YouTube or wherever you're listening to podcasts so you can get the coverage there as well, or maybe even both places. Then you can watch us and listen to us. It's a win-win for everyone, right? Let's go back to this. Kohberger's legal team seems to understand this. They've already tried unsuccessfully to introduce evidence that he has the autism spectrum disorder. I shouldn't put the word "the" in front of it, but you got the autism spectrum disorder, the ASD, a diagnosis that they likely hoped could help explain certain behaviors or demeanors if jurors begin misinterpreting his expressions in court. But the judge shut that down. The court ruled that unless he testifies that his autism is not relevant. And that decision matters because it tells us something. Even his own defense seems to know that putting him on the stand would be a gamble. Maybe even a very, very dangerous one. And I don't know that they thought through the whole autism spectrum disorder thing, because it's a spectrum. You can be super crazy, highly functional. Hey, like me. And live a very, very normal life, but our brains think a little bit different. Or you can be like him, out there, not using it for good, and be very standoffish, even when you don't intend to be. A lot of people on the spectrum have a lot of difficulty relating to other human beings, feeling emotions, feeling empathy, and things of that nature. I do not. But it is part of it. Like I said, it's a spectrum, and they could guess a lot of us are on it without even knowing it. But that's the thing. Just because you don't feel those emotions and you're not projecting those emotions to the crowd, it doesn't mean that you're necessarily a killer. It just means that that's how your brain works. But if your brain also does work that way, it does kind of check some of those boxes for, you may have the propensity to be the killer. Because if you're not feeling anything when you're doing it, or if that's the only way you feel things, you're going to find a lot of killers. A lot like this. I could probably have made that argument had they known that back in the day. Let's talk about the elephant in the room, or this case, the white Hyundai Elantra. Kohberger's defense has floated a vague alibi. He was out driving round alone when the murders occurred. No specific destination, no witnesses, no security footage backing it up, just him driving. The kind of alibi that lawyers call a solo alibi or bullshit. And it's about as thin as it sounds. The only person who can confirm it is Kohberger is himself. That's not an alibi. To do that, he would have to testify. He'd have to take the stand, swear under oath, and lay out his version of events. And that's where things get tricky, because once he's up there, he is fair game. And to understand just how dangerous that decision can be, let's look at a few other high-profile cases where defendants with legal or law enforcement backgrounds, people who on paper should have known better, decided to take the stand. And let's just say it didn't end well. Ted Bundy is the gold standard for this. Bundy had studied law. He kind of knew the system, or at least thought he did. He chose to represent himself during his 1979 trial in Florida, and even went as far as to cross-examine witnesses. At one point, in a moment that was more disturbing than theatrical, he proposed to a witness on the stand to exploit a Florida marriage loophole. Bundy was smart, no doubt, but his narcissism was louder than his strategy. His decision to testify, to speak directly to the jury, didn't make him look sympathetic. It made him look smug, detached, dangerous, and that was that. Then there's Manuel Pardo, a former Florida police officer turned vigilante. Pardo took the stand during his 1988 murder trial and admitted to killing 9 people. He did not deny it. He embraced it. He called himself a soldier on a mission, said his victims were drug dealers who had no right to live, and asked the jury to give him the glory of execution. It wasn't just a confession, it was a manifesto, and predictably it led to a conviction and a death sentence. Whatever legal insight Pardo thought he had, it was drowned out by the sheer weight of his own words. Jason Van Dyke's case is a bit different. He was a Chicago police officer charged in the 2014 shooting of Laquan McDonald, a black teenager. Van Dyke took to the stand and claimed self-defense, saying he felt threatened. But the dashcam footage told a different story. 16 shots! Most of them after McDonald had already collapsed. The jury didn't buy the self-defense argument. They convicted him not of first-degree murder, but second-degree, which still landed him in prison. Even with police training and courtroom composure, Van Dyke couldn't talk his way past the evidence. So, if these guys, Bundy, Pardo, Van Dyke, couldn't pull off testifying with their own backgrounds in law enforcement, what makes it any easier for Kohberger, who studied criminology? And to be fair, there is one case where a defendant with a policing background took the stand and actually walked free. Curtis Reeves. He's a retired Tampa police captain, 79 years old at the time, on trial for shooting and killing a man in a movie theater after an argument over cell phone use. Reeves testified that he feared for his life when the younger man confronted him, threw popcorn, and allegedly became physically aggressive. He explained that, in that moment, the man appeared threatening, like a monster. The jury acquitted him. But that was different in nearly every way. Reeves wasn't accused of a premeditated quadruple homicide. His case hinged on whether the jury believed his fear in a split second. His age, his demeanor, and the narrow legal question of threat perception all played in his favor. The jury needed to hear from him to make sense of what happened in that moment. And he delivered it in a way that, at least to them, sounded reasonable. It's not the situation Kohberger is in. If he testifies, it's not to explain a moment of perceived threat. It's to account for a massive web of circumstantial evidence, unexplained behavior, and a brutal crime scene. He wouldn't be giving a 2-minute description of a single decision. He'd be there to walk jurors through a timeline where nearly every piece of evidence contradicts him. And if even a single part of his story sounds rehearsed, evasive, or implausible, the prosecution will seize on it. They'll take a scalpel to it. They'll make sure the jury notices. Which brings us back to the central tension. Kohberger's defense team has every reason to keep him off the stand. The risk is enormous. The upside? Maybe jurors believe his alibi. Maybe they think he seems too credible. But that's a long shot, and they know it. Still, there's one variable they can't fully control. Him. Because if Bryan Kohberger, despite everything, insists on speaking, if he demands to take the stand, it changes everything. And that's the question we're left with. Not just should he testify, but what happens if he does? Because if this is the gamble he chooses to take, the trial won't just be about forensic and timelines anymore. It'll be about performance, perception, personality, in a way than it already is. So what would it actually look like if Kohberger took the stand? And more importantly, how would a jury, 12 people who've never met him, see him when he does? Well, let's take a look at that. Bryan Kohberger isn't just any murder defendant. He's someone who studied the system and now holds his life in its hands. He was pursuing a PhD in criminology, learning the ins and outs of criminal behavior, legal processes, forensic science, and criminal justice theory. And now all of that academic training is under the microscope, because if he takes the stand, that background doesn't necessarily make him more credible. It might make him more suspicious, actually. Jurors don't respond to textbook intelligence the same way a professor might in a courtroom. Credentials can be a double-edged sword. Only one side. They can imply authority, awareness, and sophistication. But on the other, they can come off smug, calculated, or even manipulative, especially when the person holding them is accused of using that very knowledge to commit a violent, premeditated crime. That's the issue at the heart of the Kohberger dilemma. If he were to testify, the jury wouldn't just be hearing from a man accused of murder, they'd be hearing from a man who, on paper, studied how to get away with it. It's not just an abstract concern. There's something seasoned professionals here have been weighing in on. Retired FBI profiler Mary Ellen O'Toole has noted that Kohberger, despite his academic background, appeared to make several rudimentary mistakes that contradicted the myth of him as some criminal mastermind. For example, he allegedly left a knife sheath with DNA at the scene. His phone was tracked moving around that area that night. His vehicle was captured on surveillance cameras. O'Toole's take was blunt. People are giving the suspect too much credit for his training. In her words, he wasn't a very good student of crime. That's a critical insight because it cuts against the idea that his education gives him an upper hand in court. Instead, it highlights a blind spot. Just because someone has read about criminal procedure doesn't mean they're equipped to navigate it in real life, especially under pressure, especially when they're accused of murder. Academic familiarity with the system might prove a false sense of confidence. But confidence in a trial doesn't guarantee credibility. In fact, it can erode it. Jurors are human beings. They read body language. They respond to tone. They pick up on subtext, whether they're trained to or not. Kohberger's legal team does know that, which is why they attempted to introduce information about his diagnosis of autism spectrum disorder. They wanted the jury to understand from the beginning that certain behaviors, like lack of eye contact, flat affect, or monotone speech, weren't signs of indifference or deceit. They were neurological. They were part of who he is. But the court ruled that information inadmissible unless he testifies, meaning if he does take the stand, jurors may witness those traits firsthand without any context for understanding them. And it doesn't mean what Ann Taylor said either. It may mean exactly what that is. A complete lack of those emotions. That's why he's not showing them. It's not that they're brewing inside and he just doesn't know how to express them. They're just not there. And that's where things get dangerous. If Kohberger appears stiff or emotionless, if he avoids looking at the prosecutor or hesitates during questioning, a jury might interpret those things as guilt, not because they're trained to make those assessments, but because they're sitting in a courtroom trying to decide who to believe. And people, when asked to judge truthfulness, often rely on instinct. Does this person seem trustworthy? Do they seem honest? Do they seem human? If Kohberger's demeanor doesn't match what jurors expect from an innocent man, it could tip the scales against him even more than they already are, no matter what he says. Now imagine how that could collide with his academic voice. If he speaks like a criminologist rather than an accused man fighting for his life, it might come off as cold or detached. If he starts referencing legal terms or procedural theory, it might feel less like testimony and more like a lecture. If he corrects the prosecutor or challenges a line of questioning like he's back in a seminar room, the jury could see him as arrogant or evasive. This is what some lawyers call the professor trap, when educated defendants over-explain, over-assert, and ultimately overplay their hand. And was he capable of any of those things? I think the jury's out on that too. But it's something to consider. There's also the matter of his past research. Kohberger, during his time in graduate school, conducted a survey asking convicted criminals about their thought processes while committing crimes. The defense would likely argue that it was academic and detached. But to a prosecutor, and potentially to a jury, it might look like something else entirely. A fascination, a study of how to avoid detection, a blueprint. Prosecutors could draw a straight line between that project and the accusations he now faces. And to that, his reported academic connection to Dr. Catherine Ramsland, an expert on the BTK killer, and the optics get even murkier. These aren't criminal acts, but in the theater of trial, perception shapes belief. Let's say Kohberger testifies and delivers articulate, technically accurate responses. He outlines his timeline, explains inconsistencies, and tries to rebut the evidence against him. It's not enough. In a murder trial, the jury isn't just listening to your words, they're watching everything else, the pauses, the phrasing, the flashes of emotion or lack thereof. And if he slips up even slightly, dodges a hard question, contradicts a prior statement, or flashes irritation under cross, it doesn't just hurt, it can collapse the entire defense. There's a reason Kohberger remained silent at arraignment. He didn't enter a plea himself. The judge had to do it for him. That silence wasn't just procedural, it was strategic. His attorneys seemed to be building the case around technical rebuttals, forensic timelines, digital data, expert testimony. They're leaning into the evidence, not the narrative, and that's telling. It means they're avoiding the very thing that testimony would require: emotion, vulnerability, and personal appeal. Breaking from that strategy by putting him on the stand would be a major shift. It would signal desperation or overconfidence, neither of which plays well in front of a jury. The defense likely knows that the testimony is a last resort, because the moment he opens his mouth, everything changes. The jury is no longer evaluating just the facts, they're evaluating the man, in his own words. Even if Kohberger gave a well-delivered, logical account of his movements, it may not resonate. Intelligence is not the currency in that room. Emotional truth is. Jurors are not grading an exam. They're deciding guilt or innocence. And in that context, a defendant who comes across as too polished, too everything, too rehearsed, can feel like he's hiding something, even if he isn't. That's the real risk. Not that Kohberger will say something overly incriminating, but that he'll say everything right and still lose the room, because he doesn't need to just make sense. He needs to make them feel something. That's where education, training, and composure can start to work against you. In the end, the question of whether he testifies isn't about academic ability. It's about the unpredictable, deeply human space between what someone says and how they're heard. And that space, in a case like this, can make all of the difference. What do you think? Let me know in the comments section. Love to hear your feedback on this case, and whether you think he should testify, shouldn't testify, what it would look like if he did. It's all theoretical right now. We're not even in trial. But I just wanted to bring this conversation piece out there. So tell me on YouTube or on X what your thoughts are. And again, be sure to press subscribe so you don't miss our coverage on this case or the many that we cover for you. We have a channel specifically for this. It's right there. The Idaho murders, the case against Kohberger. So if you just want to follow the Kohberger case, it is there for you wherever you get podcasts. Find me on Twitter at TonyBPod, or search Hidden Killers with Tony Bruschi on YouTube. I am Tony Bruschi. Thank you for listening. We will surely talk again real soon.
Craving non-stop true crime updates? Press subscribe now and get the latest cases, analysis, and expert commentary delivered straight to your feed. Only from the Hidden Killers podcast and True Crime Today.